And vis-a-vis putting all of that together, this court judgment should not even have been, come forth. What's your take?
That assertion is not correct. The court processes are public documents, and sometimes the best way to prove their content is to show them. The PDP went to court to stop the conduct of that election for various reasons, and also requested that the INEC register should not be released to the RISEC so that RISEC does not go ahead to conduct the election. That was the beginning of this process. And the Federal High Court in Port Harcourt requested the defendant, so to speak, to show cause why that prayer would not be granted. In other words, they were asked to come and defend themselves, which is ordinary and normal. Rather than do that, they appealed against that order by the court inviting them to come and defend themselves, and made it impossible for the Federal High Court to proceed with the matter since they had already gone upstairs. And the court ruled that because the issue of the voters' register is the rest in the matter, it was important that parties stayed away from doing anything that will tie the hands of the court if at the end of the day the suit eventually returns to the Federal High Court. That was where we were when the RISEC hurriedly disobeyed that order of staying action and conducted the election.
Wait, you're insisting there was an order to stay action?
A subsisting order.
Pardon?
Let's talk about, you're insisting there was a subsisting order to stay action?
There was a subsisting order, yes.
Wow, Mr. Peterson says there was no such court order.
No, the order is do not release. The order was directed at INEC, do not release the voters' register to the RISEC. And without the voters' register, which is a precondition for the conduct of a regular election, there was no way anybody could have gone ahead to conduct a proper and legitimate election.
But in the case where RISEC already had these registers in their possession, you know, was the court order still, was it still in place? Was it still necessary, or was it supposed to be adhered to since the RISEC already had these registers in their possession?
They could not have had it because even the INEC came out publicly and said that they have not given the official register of the River State voters within their possession. So RISEC, INEC said so, through a press statement issued and published that they have not given the voters register to RISEC. So which register then did RISEC use to conduct the election?
Okay.
That is the question that RISEC needs to answer.
Okay, Ms. Walker, please stay on the line. We'll come back to you. Mr. Peterson, if there's an order, do not release the voters register to RISEC, that's to INEC, and INEC says they did not. So which register did RISEC use to conduct the election?
Thank you very much.
And where
First,
did they get
in clear terms, there was no such order. And I put it to a Oka to prove that there was such an order. The second thing is that as part of RISEC's reply to the original summons, RISEC said, please, we already have the register given to us by INEC, approved by Professor Joga, who, as he was then chairman of the Independent National Electoral Commission, not the administrative secretary in INEC Port Harcourt. The national office of INEC has formally released the register to RISEC.
Before that court order?
Before even the court process started.
Okay, but hold
and
on.
so RISEC said in their reply that we're not talking about register because we already have the register.
But then,
and so even when
should the RISEC have gone ahead since there's a
Since
court
there was
order
a
saying
there's no such order.
There's no such order.
Now, if the issue was register, RISEC had the register. Court says maintain status quo as it relates to register. That means continue to keep the register you have. I don't know, this is very clear. We already have the register. We've gone past this stage. A woman is pregnant, and the doctor says if you deliver, that it will jeopardize your health. The woman said, I delivered yesterday night. They said, no, don't deliver. That's an analogy to make the common man appreciate what's going on. And it's also important to state that you refer to the interpretation of the law by Emmanuel Agoma. Emma Agoma was the counsel to PDP who filed the matter on behalf of PDP. He is now the Attorney General of Rivers State. You can see the conflict of interest. He's the same man interpreting the position of the law as it relates to PDP, RISEC, and Rivers State government. You are a lawyer. Is it ethical? And parties, both APC and the 22 elected local government chairman, rather, wrote to NJC protesting this, protesting the conduct of the judge, because the judge who said, listen, my hands are tied by virtue of the fact that these things have gone upstairs to the Court of Appeal, and that we cannot proceed until it comes back from the Court of Appeal. And so when did he give this order that RISEC should not conduct elections? I challenge anybody, and I asked Emma to put, I asked Emma Oka I put him to convince the public that there was an order to RISEC not to proceed with the elections, or that there was an order to RISEC, INEC rather, not to release registers to RISEC. No such order exists. It can only exist in the figment of somebody's imagination.
Okay, we'll come back to the issue of orders and not orders. Let's bring in Mr. Wadioke. There's this other portion of the Electoral Act. I mean, yeah, the Electoral Law and Guidelines that talks about 90-day notice to political parties for the conduct of the elections. Now, one of the issues that the PDP took to the court, or is complaining about, is that they didn't get 90-day notice before the local government elections. Should that also apply? Should that be?
Definitely.
Do they have a basis for complaint?
Definitely, definitely, because ultimately the state law on the conduct of local government elections must tally with the Electoral Act as amended. And you've seen even the Supreme Court, deciding on this, that where the notice, the length of notice was not enough, definitely the election will be invalidated. For instance, we had that in the Osun State petition, appeal against Action Congress of Nigeria, where the Supreme Court also invalidated that election based on the length of notice. Because what happened in that matter was that the length of notice given by the State Electoral Commission was, I guess, shorter than that prescribed in the Electoral Act. And if you go to paragraph 11 and 12 of the second schedule to the Constitution, paragraph 11, for instance, says that the National Assembly actually has the power to make laws concerning the conduct of local government elections. Paragraph 12 now says that whereas the State Assembly could make similar laws, if it's inconsistent with that made by the National Assembly, which in this instance is the Electoral Act, it becomes invalid and null and void. And that was what the Supreme Court held in that instance. So, if indeed the period given by RISEC was shorter than that prescribed by the Electoral Act, obviously they will have a valid case.
Election.
Now, thank you very much. I don't want us to put out wrong information to the public. First is that the Electoral Act is made pursuant to the provisions of the Constitution. The power by the State House of Assembly to make laws governing the conduct of elections as it relates to local government councils is also made pursuant to the provisions of the Constitution. Is that correct? Now, the Rivers State House of Assembly has made its own law governing the conduct of elections as it relates to councils, which is within its purview. Now, this law made some provisions. If you are not comfortable with the law, you ought to challenge that law in court. That law was made several years ago, and elections have been conducted based on that law. If at any point in time anybody disagrees with the law, you should challenge it in court. Nobody challenged it in court. I'll talk about the present circumstance. So the Rivers State House of Assembly made a law within its powers and within its jurisdiction. When PDP approached the court and raised it as an issue, they ordinarily should wait for the court to determine on that. The court has not determined that yet. And so it is not a substantial issue in this matter until the court makes pronouncement that that law made by the Rivers State House of Assembly is invalid. For as long as no court has vitiated the law made by the State House of Assembly, that law stands.
But no, when he said something about lining it up in concordant, how do you put it now?
Yeah,
lining up with the electoral, in consonance with that law made by the National Assembly.
No, you are not able to distinguish the two issues. You cited the Osun case, which is totally different from the Rivers case. And I don't think I want, because for me, it's not a key issue right now. I don't want us to dwell on that. Because for all intents and purposes, it's before the court to determine. And they've not dwelt on that issue yet. For us, the key issue is that, one, this is crass impunity. For a matter that is not before a judge, for a judge to give a ruling on a matter that is not before him, technically speaking, that matter is not before Justice Akambi. Because he has adjourned, sine die, and there's a valid order already of a court of competent